How's it going, guys? It's Jeff here with another special edition for in our Delphi series. Um, this time, I realized early that I don't need the headphones since it's just you and I don't have to listen to hear anybody else and not get feedback and all of that stuff. So yeah, no headphones this time. That way, I don't feel like there's a vice on my head. Anyway, so there has been a lot of things going on in the Delphi case. I told you guys that I was going to come back around to the motions. And before I got a chance to get back to the motions, there has been a decision on those motions. So, and it honestly is exactly what all of us knew that it was going to be. We knew that Judge Gull was not going to grant any of this stuff. And listening to the interviews with Andy Baldwin, he knew that it was a long shot for Judge Gull to uh, agree to any of the things that they had in the motions. So it's not surprising to them that now this has to move on to the next phase. But yeah, there is some wild stuff in there. And yeah, so I wanted to go over it. I wanted to look at it. I actually printed out all of the motions, so I have all of that. I am not going to read it word for word because that would take forever. And yeah, I'm not going to read it word for word. If you want to hear it read word for word and go through it line by line, go and check out the defense diaries because they do an excellent job at that and reading through every single motion. Allie often is ready to kill Bob, but Bob gets through, and it's great because they really give us the defense perspective and show us exactly what the defense is thinking and why they're thinking the way that they are, why they would choose to go down this route, and it's fascinating. I am here to give you a summary of my understanding of everything and to look through it. And yeah, they have a whole different perspective, and I love listening to them. But so on, let's see, looks like 120, almost a month ago a month ago tomorrow, because it is the 19th today, February 19th. But on January 20th, the defense submitted the motion to correct errors. And so many of you have heard a lot of this already. And, there have been a lot of podcasts that are talking about it, but I think some really, really interesting stuff has come out in the last week. And even though all of these motions have been struck down without any hearing at all, which should not be surprising because Judge Gull basically did that the entire trial, right? There was a lot of things that were not let in. There were a lot of things that were not addressed. She found fault with the defense many, many times about just about everything else, everything that they were saying, all of the evidence that they were trying to present, any of the third party stuff, any of the Odinism stuff, all struck and not allowed at trial. And now here it comes back around again, and they're trying to bring it up because the whole point of this motion to correct errors is to get a new trial. So the defense is actively saying, hey, you guys did not get this right. This was not presented correctly. The state lied about certain things or allowed lies to happen at trial. So because of those things, we should get a new trial. And again, Judge Gull struck that down and said, no, you're not going to get a new trial. So we're going to go through this. I'm just going to go through what they presented. There were several motions to correct error. The first one they said is the violation of the 6th and 14th Amendment. Mr. Allen was deprived of counsel at the safekeeping proceeding on November 3rd, 2022. That proceeding was a critical stage in which Mr. Allen was entitled to be represented by counsel. under United States versus Chronic, 466 U.S. 642, and its progeny. The court must presume that Mr. Allen was prejudiced by being unrepresented during that proceeding. And so they go through to lay out a whole bunch of evidence that they believe builds their case to say that the prosecution knew that Allen had counsel at the time, and they did not have that counsel there at that hearing to represent him. Ultimately, that ends up getting him placed in Westville, where all of the psychotic episodes happen, and ultimately all of the confessions. So that the defense is saying that this is a critical stage. If this did not happen the way that it happened, then he would not be in Westville. He would not have confessed, So again, this is a long shot. And I'll be honest with you, when I read all of this stuff, this motion to correct errors, I thought that there were some interesting points. I did not see where very much of it was new evidence. And so, often to get an appeal, to get a new trial, you have to have new evidence. And later on, and when you hear this, when they submit the motion to strike the state's response, they talk about the fact that in Indiana, it does not have to be new evidence, which I thought was really interesting. And I'll read that when I get to it, what the defense said about that, because I was not aware that that was the case. And I still don't know if it's completely accurate the way that they are presenting it. So one of the things that happens in a lot of these motions is that there's a lot of legalese, right? There is a lot of jockeying for position and bringing up all of these precedents that have been set in the past, other court cases where this has happened. And now the judge has to decide if that holds any weight for the trial. So does it mean anything at all in this instance? And sometimes it does. Sometimes there is a precedent for it, and they will they'll be granted what they want. In this case, that did not happen. But in this first one here, they go through and they talk about all of that stuff that they knew, that the state knew that Allen was already represented, that Kathy Allen had hired the attorney Brett Gibson to represent Mr. Allen. There was apparently an email that was sent that should have been the understanding that he was the one that was retaining counsel at that time. And of course, they we'll get to the response. But they go through all of that. They put in a bunch of exhibits that show the emails and things like that, that show that the state should have known that Allen had counsel during this time, and that counsel should have been at the safekeeping hearing. Let's see. And I don't want to go through all this because it is rather lengthy. Let's see. They also in here talk about how he was originally at the White County Jail. So it says shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. Let's see. So on November 1st, that letter should have been mailed. They go on to say that the safekeeping proceeding was plainly illegal from start to finish. Lazenby transferred Mr. Allen to the White County Jail on October 28th with no safekeeping order in place. Lazenby had no standing to make a safekeeping request on November 3rd due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28th. Once Mr. Allen was in the White County Jail, the White County Sheriff was authorized to make a safekeeping request because Lazenby had no standing at that point to even make a safekeeping request. Judge Diener had no jurisdiction to consider it. And then they go on to talk about how Mr. Allen had the right to look for another judge other than Judge Diener to decide whether they could even go through with the safekeeping. And of course, this is what goes. One of the reasons why this is so important in this case specifically is because this takes him out of a county jail where you would typically keep like a pretrial detainee, right? He's not convicted of anything yet. He's waiting trial, and then takes him and places him in Westville in basically solitary confinement for months and months and months and months and months. So this is a really big deal, the fact that he got moved from one place to another. And later on, what you'll find out is they cite that it was overcrowding that actually got him moved. So it's really kind of wonky there and what that means. But they go through all of this, and you guys can read it. You know where to find it all. So the next one that they talk about in here is the violation of due process clause of the 14th Amendment. The state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing that that testimony was false before it was elicited or failing to correct it once it had been elicited. Okay, so Brad Weber in his early interviews could not remember if he went home or not. Matter of fact, he said that he did not go right home because he had been gone a week previous to that. He was on vacation. And typically, when he goes on vacation, when he comes back, he has to go and service the ATMs that he has. Brad Weber owns a bunch of ATMs scattered around the area. He will go and service them, make sure that they're still dispensing money, making sure to take money out so that he can deposit it. And after a week long of not being there, he would have to go and service those. He said that, I believe if I remember correctly, he said that he typically services those every other day. So if it would have been a normal week where he was in town the previous week, he may not have serviced it on that day. However, since this was the first day that he was back in town after being gone for several days prior, he would have almost certainly, before going home, gone to service his ATMs to make sure that they were dispensing money, that they were still functioning correctly, that there wasn't any maintenance that needed to be done, because that was part of the business that he had. So the defense is stating that, okay, if he said that in this prior interview, why are you now allowing it at trial for him to say that he was home by 2:30? Because his original testimony was not that. His testimony was that he didn't get home until later than that. And so says that the state introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13th and arrived home in his white cargo van about 2:30 p.m. For Mr. Weber's testimony, the state argued that Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take the girls across the Deer Creek to kill them on Ron Logan's property. So the arrival of Mr. Weber's van at about 2:30 is essential and was a detail only the killer would know. And we know that that this did have an impact on the jury now that we know that at least one of the jurors has come out and talked about it. So, like, if this is the case, this is essential to the state's timeline. they would have to have Brad Weber coming home directly after being at work at the Subaru factory. He would have to come straight home. Richard Allen would then have to see the van to fit the confessions that he made. And we know that the confessions are a really big deal, right? The confessions ended up being a big deal for the jurors, as well as the fact that they believe that he's bridge guy. So so it's, you know, it's interesting. So, but they say the problem is the state contended that they died near to 2:32 p.m. When the Apple Health data from the phone showed that the phone stopped moving. If the arrival of Mr. Weber and his van interrupted Mr. Allen, forcing him to cross Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32 p.m. When, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44:54 p.m. on the 13th. His arrival about 2:30 could not have been a detail only the killer would know, because it didn't happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. So they also pull a video from a security camera at a house, and that video shows the time that that he was getting home. Now, there are a couple problems with this video. Number one, the time is inverse. So it says that it's 12 a.m. It's actually 12 p.m. So yeah, it's a little bit wonky, but this is what happens when you have people that have security cameras. They're not always correct in there. It says the security camera was set 12 hours behind. This is apparent due to the daylight and moonlight in the video. According to the time and date stamps on the security camera recording, the van enters the frame at approximately 2:44:33 on February 13th. It also shows a white vehicle continuing into the private drive to the Weber's property at approximately 2:44:54. And then you can view it from this YouTube link that they have in there. So they show some zoomed in clips that they believe proves that it is Brad Weber's van for sure. But if that video is correct, there's no way that he was home at 2:30 for all of their timeline to work. So that's what they're saying there. And they're saying that the state either knew about it and they lied, or the state put them up to it, I guess, and they lied. So the next one is they talk about, they submitted this as a motion that Ron Logan's confession to Reese Davis before May 15th, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Now, this is interesting. And it is really what we'll get to later on, because this is a big deal. And Cryptix, I know you will be watching this. Love you, brother. But he has really, really been on the Keegan Kline train. And before I even understood some of the connections with Keegan Kline, but here his name continues to come back up over and over again. And you got to wonder, does this have something to do with it? And so in this, Ron Logan confesses to Reese Davis, who spent time in prison. They were in close proximity together in jail. And let me see here if I can see where. So anyway, Logan confesses to Reese Davis step by step how he killed the two girls. Now, again, the girls were found on Ron Logan's property, right? So so he tells Logan how he tells Reese how he burned his clothes in a fire pit and where that fire pit was. So this gets a little bit confused later on, but Logan is talking about burning his own clothes because he was covered in blood from the girls. So he mentioned that he used two different box cutters and struggled with one of the girls and thought that drops of blood from his nose ended up on her clothes. Reese also advised that he killed the older girl first. So he would have killed uh, one of them at the scene and taken the other one away and brought back later, is what it seems like. So they go through and they show the letters, uh, or at least the writings, I think of Reese Davis in explaining what Ron Logan had confessed to him during this time. But they have that in here, and it is pretty detailed. Now the crazy thing is, and Reese Davis is going to come up again later because he seems to play a bigger part in this than we would have realized. And you wonder in this, like, who the hell is this Reese Davis guy, and how did he all of a sudden pop up in this whole case? And it starts out that these confessions came to Reese Davis, right? June 21st, 2017. Right? The girls were killed and they were found on February 14th, 2017. February, March, April, May, June. 4 months. 4 months later, 4 months and a couple days. And Ron Logan is confessing because he's in prison for something else now, right? And he's confessing to this guy long before Richard Allen was even thought about as having any connection into this case. Ron Logan is confessing to Reese Davis. Now, how is this not looked at or brought up? Now, uh, yeah, it's crazy. Uh, and again, there's some details in here that end up really fitting the what they find at the crime scene, like the I can't think of the name of it now. The pathologist talked about how he believed that it was box cutters that may have been used, one with a guard, one without. And so now you have Ron Logan who is copping to the fact that he used two box cutters, right? So, like, there are some things here that seem like it should be investigated, that it might be a thing, and there might be like some real legs on this long before they ever get to Allen. Okay. Let's see. So addition to the other details that fit the known facts, Ron Logan confessed to Reese Davis that he used box cutters to kill the girls. Let's see. Dr. Kaur said 7 years earlier, said that the girls could have been killed by a box cutter. So if it was said 7 years earlier before the trial of Richard Allen, they would have had probable cause to arrest Ron Logan for the murders, is what they're saying. So they believe that this confession, if it was looked at early enough, it should have really kind of thrown out Richard Allen's trial at all, and Ron Logan should have been on trial. So, and it would have changed this entire trial if it was admitted into evidence. Now, the state will come back and we'll go through what the state says about it and how they combat this stuff here in a minute. But the next one is they talk about the affidavit of Stacey Eldridge, states that the dirt or water damage to the phone could not have caused the auxiliary jack on the phone to log a wired headphone in and a wired headphone unplugged. Mrs. Eldred's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. I'll be honest, I think that that is probably out of the several of these, or the 5 of these that we're looking at, probably the weakest one. I get it. They're going through this because, the guy on the other side for the state, literally after she gave this testimony, went out and did a Google search and said that it could be dirt or water damage. And here's the thing, though. Stacey Eldridge was at the trial. She discussed this already. The jury didn't believe it. And so it's like, this is not newly discovered evidence, right? Should it have been submitted for trial that this guy did a Google search at the break and found this information? It was not expert testimony. It really is a load of shit that they were even able to combat that with this Google search. But it was allowed in, and so maybe it caused a certain result and may have had some impact into that. But the truth is, it's too late now. This is not newly discovered evidence. And this is kind of the problem with the motion to correct errors, right? Is that there is very little of this that seems to even be close to newly discovered evidence. Really, what it looks like is ineffective assistance of counsel on the defense's side, obviously, because like a lot of this stuff they could have combated during trial. Specifically, all of this stuff about the phone and the wired headphone being plugged in the dirt, the water damage on the phone. Like, if somebody would have just actually done some research and looked at the phone, because it doesn't seem like either of them did that, because in none of the court records is there any mention of any water damage on this phone. So, how are you going to say now there's water damage? Don't you think that even the state should have taken that phone apart, looked at it, determined that there was water damage, and logged that somewhere? The fact that it's not logged at all, and then they just did a Google search during the trial, seems like there was probably no water damage, probably no dirt in the port, right? So, you would think that that would be something that they would bring up, but I think they got caught with their pants down and they had to do this Google search. But again, this is not newly discovered evidence, which makes it problematic when you're talking about trying to get a new trial for newly discovered evidence, right? The other thing is with this, and we'll look at this first, the safekeeping hearing, they talked about that during trial. It didn't seem to make a huge bit of difference because they filed motions and they filed different things about the safekeeping hearing. So I don't know how that's newly discovered evidence. The white van, they talked about it at trial. They showed some things. The white van became an issue at trial, but why didn't they bring up the fact that the white van had been talked about in 2017, 2018, right? It was on podcasts. It was out there. It was certainly something that oh my goodness, I can't think of her name now. Walla would have known, right? She was following this case and she would have known it. So, it was something easy to be able to feed to Richard Allen in his psychotic state. And so, when you look at that, why didn't they combat that during trial? Why didn't they bring that up? Why didn't they talk about that? How did they miss that? Is it newly discovered evidence? No, because they already talked about it at trial. So I think the stuff with Ron Logan is interesting. But again, they've got a problem there because the stuff with Ron Logan is pointing at a third party, right? And they were not allowed to deal with any third party stuff at trial. So this becomes an issue because is it really ineffective assistance, or is it the fact that they were hamstrung from the very beginning and they couldn't bridge that gap anyway? I don't know. It's like a catch-22 here. I really don't know how that plays out. But I want to go to the state's response to this because the state's response is interesting, of course. And so you go back to the first claim about the safekeeping. The state's response is that if an inmate is at risk of serious bodily harm or poses a risk to himself or others, he can be transferred to another county jail or facility to be housed. The state does not require a hearing and can make the determination on the motion alone. So if they filed a motion that said, hey, we need this person moved because of any of these reasons, they could just say, okay, move them, right, without any hearing at all. The fact that they even had a safekeeping hearing is not necessary, which means that Allen did not have to have counsel at that hearing, is what they're saying. The state does not require a hearing and can make the determination on the motion alone. The defendant did not declare that he had counsel on October 28th, 2022. He was moved due to overcrowding, not a safekeeping order. So they're saying that they even moved him because of the overcrowding, not because they thought that he was going to harm himself or someone else was going to harm him. Tobe Lazenby filed the motion for safekeeping on November 2nd, 2022. On November 3rd, the court granted the motion without a hearing. On November 3rd, 2022, attorney Brett Gibson told the court he would not be representing Allen. Now, here's the thing, and this is the thing that baffles me about this. If Brett Gibson says, I'm not going to be representing Allen on the 3rd, didn't you have to know before that Brett Allen was representing him? So, like, it sounds like they like get themselves stuck in this one. The motion for safekeeping is not a critical stage of the trial. They're saying it's not even a big deal. On June 15th, 2023, there was a hearing on the safekeeping order. And this is what I was referring to before, that the defense has already had a hearing on the safekeeping order, which means that it is not newly discovered evidence. The court found the defense's allegations were untrue and upheld the safekeeping orders. Here we go again. The judges just keep rolling for Richard Allen. On September 18th of 2023, the defense filed for an immediate transfer and were denied without a hearing. I believe that is the order or the immediate transfer that they were saying to get him out of Westville because of all the things that were happening to him. They are saying that this had no effect on the verdict at all, which is crazy to think that it had no effect on the verdict. But, you know, this is the state doing anything it can to make sure that they get what they need. Let's see here. All right, the second one is Brad Weber and the white van, or the van. I had somebody on one of them, I said white van, and they corrected me and said that it was just van at the time or something. So van. Sorry, guys. You know, we're all kind of armchairs here trying to figure this out and trying to look through all of these things. You know, so I hope that I spark some more thinking, but I don't always get it right. I sometimes I say the wrong thing. I get the wrong name in there, or the wrong person. So please comment below and let me know. But don't hold it against me forever. Or timing and stuff. And to be perfectly honest, some of this changes, right? How it was initially reported ends up being different than how it is finally recorded, because maybe somebody mentioned it in one thing and then mentioned it again later, or somebody wrote it down wrong because they were at trial and didn't hear it correctly. That shit happens all the time. So, and it makes it really difficult since we have no transcripts from anything. to even know exactly what was said at trial. So, Brad Weber, the state responds, says that this is not newly discovered evidence and was given to the defense in the discovery. So it is not grounds for a new trial. So they're saying, hey, we already gave it to you. It was there the whole time. You could have looked through this mountain of evidence and you should have known it was there because we gave it to you. Not to mention, the lawyers were thrown off the case and then came back and had to go through everything again, right? So it's such a shitty thing to say that's the case. And then they really, the only other thing that they go through is they say that the defense chose not to use this evidence to cross-examine the witness. So when Brad Weber was up on the stand, they didn't bring it up. So this again would point towards ineffective assistance of counsel, because they didn't even bring it up during trial when they probably should have. And they're now trying to use this motion to correct errors to add extra things to the trial that were not brought at trial, because this is not new evidence either. So let's see. The first thing that they say in here is the exhibit presented by the defense is in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number, and therefore is an improper submission for consideration by the court. So, and it's funny because I'll also read the defense's response to this when they go through the strike. Let's see. It says the simple answer is that a motion to correct errors only applies to newly discovered evidence. From the defense's own admissions, this is not newly discovered evidence, but rather evidence that they have been provided long before trial. The defense chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defense trial attorneys. Therefore, it is a moot issue because it is not newly discovered evidence. They could have used it. They go on to say that they could have used it to impeach Brad Weber when he was on the stand testifying, which they didn't do. And so it doesn't constitute newly discovered evidence. And then they said that finally the testimony of Brad Weber was not the exclusive evidence the state used to convict Richard Allen. Brad Weber was on the stand multiple times, and the defense had every opportunity to cross-examine him. If anything, this evidence is no more than impeachment evidence that the defense chose not to use. So there you go. Pretty strong coming from the prosecution. All right. The next one that they react to is the Reese Davis claim of confessions by Ron Logan. So let's see. Any information pertaining to Ron Logan falls under the state's motion in limine concerning third-party motive. It's the first thing that they say. There's a third party, can't have anything to do with this trial. It says that the defense had 3 days to present evidence to meet their burden for a third-party motive. Now, this is true. They mentioned Ron Logan, but failed to meet their burden with the court. They chose not to present this evidence in that hearing. They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defense to use a motion to correct error in an effort to circumvent their burden concerning third-party motive. So essentially, when there was a time as they were preparing for the trial that they had an opportunity to enter in any kind of third-party stuff. They had 3 days to do that. And to Judge Gull, they did not meet their burden to present any evidence for third party. So that is why it was taken out. It could not be presented at trial. Now, the problem with this is if they didn't have all of this evidence, or if there was other evidence that didn't come out until later that would have affected this, that would be new evidence, which is funny because that's what we're going to get to. And that's what's coming if you guys haven't seen that yet. So this evidence, along with the video surveillance from the residence, was received by the defense on January 30th, 2024. Let's see. So they're saying that they knew that this Reese Davis confession of Ron Logan was there and was in the discovery. So the alleged confession was made to Reese Davis, who was serving 50 years for dealing methamphetamine. The law enforcement interviewed Reese Davis and submitted him a polygraph at his request. Mr. Davis failed that polygraph miserably, is what he says. That Mr. Davis gave a statement that alleged Ron Logan confessed to him that he killed the older girl first and took the younger one away from the scene, that he killed the second victim later and then brought her back to the scene. Then he went back to the scene after the search parties searched his property and moved the girls to another location, that he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned. Many of these details are directly contradicted by the evidence. The others have no evidentiary support. Now, there is a lot in that paragraph that they completely fabricated that was not actually in the confessions of Ron Logan. Like, he never talked about burning the girl's clothes. He talked about burning his own clothes. So that's a real issue. But again, this is the chess game that's played by the lawyers trying to gain their position and trying to get out the information that they want to get out, and to see how that's going to influence the judge who is going to rule on all of this. Says that even with the alleged information from Ron Logan about the box cutter, there would not have been enough evidence, been enough to establish probable cause to arrest Ron Logan. No evidence places him at the scene of the murders, unlike the defendant, who left an unspent round at the scene that was subsequently matched to a gun that he owned, that he himself asserted was never in anyone else's possession, who put himself on the bridge at the time of the abduction and wore the same clothing as Bridge Guy. Again, a lot of that stuff's not true. He never put himself on the bridge at the same time. He was there that day. And as far as the clothing, everybody in that area wears that clothing. It's a pair of jeans and like a Carhartt jacket. Like, not real hard to find that in Indiana. But the other part that they talk about there is the unspent round. And we know now that that unspent round had little to do with the jury verdict, because the jury did not believe the forensic evidence on the bullet, because it's junk science. It was ridiculous, but they used it and it ended up not being very effective, right? All right, and the last one here is the Stacey Eldridge expert opinion. Mr. Davis, nope. Here we go. There we go. Got too far ahead of myself. The state says that Stacey Eldridge is not an expert in forensic phone analysis, only in computer and network forensics. She was only eligible to testify in 2023 on forensic phone analysis. So essentially, they're saying that she's new to this and really doesn't know what the hell she's talking about. There were no headphones found with the bodies at the scene. I don't know why that's even relevant, but that's what they say. The phone did not move after 2:32. The phone was found under the body of Abby, which means that the person would have had to retrieve the phone, plug the headphones in, unplug them 5 hours later, then return the phone under the body, all while not moving the phone. Stacey Eldridge never examined the phone to determine any water damage, but neither did they. So it's kind of a moot point if nobody looked at the phone to determine any damage at all. Like, it seems very, very strange. But that was the state's response to the motion to correct errors. And so now we come to the defense's response to the state, and they file a motion to strike the state's response to the motion to correct errors. And so they go through this. Let's see. And this is there's some really, really good stuff in here. It says, in particular, on page 2 of the state's response, Mr. McLeland alleges on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant, herein attached as State's Exhibit 3. That allegation is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59. Says that, let's see, on pages 7 and 8 of the state's response, McLeland alleges the defense received the van video and any information pertaining to Ron Logan included in Mr. Allen's motion to correct error on January 30th, 2024. The allegation is supported by State's Exhibit 7, discovery release. These allegations are based on facts outside the record and unsupported by affidavit or verification in violation of Rule 59. I think it just goes through that. Let's see when it actually gets into some of the things. Let's see. Well, okay, they go into it here a little bit. On page 8 of the state's response, Reese Davis was interviewed by law enforcement, which he was. But Mr. McLeland also says Mr. Davis requested a polygraph examination, which he failed miserably. No exhibit of Mr. Allen's says anything about polygraph examination. These allegations by Mr. McLeland are based on facts outside the record and unsupported. Says that on page 8, he says that Ron Logan told Mr. Davis he removed the cell phone battery from the phone and left the phone behind, and he took the girls' clothing from the scene and burned them. Nothing in any of Mr. Allen's exhibits pertaining to Ron Logan's confessions to Mr. Davis say anything about Logan removing a battery from any phone. Similarly, nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Reese Davis say anything about Logan burning the girls' clothes. These allegations are based on facts outside the record. Again, he mentions burning his own clothes. Let's see. So on page 9 of the state's response, they say that Sergeant Cecil was able to observe photos of the phone when it was found. And we just recently got to see these photos of the phone. It looks like it has some beaded water on the screen. Let's see. In addition to not saying whether Sergeant Cecil actually observed those photographs, this allegation is based on facts outside the record, blah, blah, blah. I wonder if that, okay. They go into the fact that Sergeant Cecil's trial testimony about the effects of dirt and water came from a Google search performed during a break in Mr. Allen's trial. The allegation that Sergeant Cecil's opinion then had anything to do with his knowledge or experience is based on facts outside the record and unsupported. It says also that McLeland says there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage, because that kind of damage is not registered in the logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone. McLeland said that Uh, and the state or the defense responds and says, Mr. McLeland is not an expert his and attempts here to testify as if he were one. Uh, let's see. All right, let's see. They go on to talk about Lazenby and when he was transferred and why he was transferred. So Lazenby, at the safekeeping hearing in June of 2023, Lazenby explained that Mr. Allen's transfer to the White County Jail as follows. And so tell the court what arrangements you made to have him placed in White County. He says, just a matter of simply having direct communication with Sheriff Bill Brooks and explaining my concerns of a potential safety and security of our facility and asked him if he could temporarily hold Mr. Allen for us. Okay, and were you confident that Mr. Brooks and his facility was adequate to hold him on a temporary basis? At that time, yes. So, Lazenby said nothing in June of 2023 about an overcrowding issue. But now all of a sudden it's overcrowding is the reason why, right? So, um, yeah. So those are a whole bunch of problems. Uh, However, with that being said, we know that it didn't make any difference because Judge Gull came in and struck them all. So, out of all of those motions that came in, I've got the order here that came out yesterday. Oh no, where's the? Oops, I guess I didn't print that out. Well, that's a shame. I'll have to pull it up. On 2018-2025, defendants motion to correct orders or to correct abstracts of judgment filed on January 20th, reviewed and denied without hearing. And then the court, having received defendants' verified motion to correct errors, also filed on the same day, the state's response uh, to motion to correct errors filed February 4th, and the defendant's verified motion to strike the state's response to the motion to correct errors filed February 14th. Now denies defendants Richard Allen verified motion and further denies the motion to strike without hearing. So, so all of that not there, not going in, has nothing to do with the trial, right? So all gone. Now, the one thing that's really, really interesting about this is that she did not strike the motion to preserve evidence. And that is the last thing that we're going to talk about because this is a big deal. This is crazy, crazy information that has come out and adds to the Ron Logan confessions and may really be something if it's true. Again, we don't know if this is true. Reese Davis could be lying. He could have the wrong information, but man, I'll tell you, for a guy that's in prison right now with Keegan Kline and is in prison for another 40 plus years, right? On this methamphetamine charge, which seems to be really a serious heavy penalty that he's been hit with, but that doesn't make any difference. Different case altogether. But he is in there with these people. It is not in his best interest to rat people out while he's in prison, right? So the fact that he's doing that seems to me to be that he's putting his neck out there, and it would be crazy to lie about something like that, right? So what's interesting is there are a lot of different crazy scenarios for this. And let me say this too, well, I'll say that later, but let me pull this up real quick because I didn't print it out. But it says here on February 12th, 2025, Richard Allen's counsel, Andrew Baldwin, met with inmate Reese Davis at the Newcastle Correctional Facility. During the meeting, Mr. Davis informed Attorney Baldwin the following, that he was in the unique position of having both Keegan Kline and Ron Logan during their stays at the Newcastle Correctional Facility. Having met both of them, he talked with Ron Logan about the Delphi murders on multiple occasions. Over the course of time, Logan confessed to his involvement in the murders along with two other people. During those conversations, Logan provided certain details of the crime that only the killer would have known, but never divulged who the other two people were, who the other two people involved in the murders were. In and around March 24th, 2024, Keegan Kline was placed in the same general area as Reese Davis, and at some point apparently learned that Reese Davis had talked to Ron Logan while Logan was incarcerated in Newcastle. Over time, Kline began questioning Reese Davis as to Reese Davis's conversations with Logan and whether Logan had ever mentioned Keegan Kline's name to Reese Davis during those conversations. Reese Davis began to realize that Kline may have been one of the members of the crew that Logan described as being involved in the murders. Over time, Keegan Kline began to reveal information about the Delphi murders that corroborated details Ron Logan had revealed to Reese Davis several years earlier. Some of the details, now remember, the confessions of Ron Logan happened in 2017, right? 7 years later, after Richard Allen is convicted, or during the time that the trial is going on, Keegan Kline is confessing to Reese Davis. Crazy. Some of the details Keegan Kline provided to Reese Davis are the types of details that could have only been known by someone involved in the killings. These conversations between Reese Davis and Keegan Kline occurred all the way up to the guilty verdict, at which time Kline expressed his relief that he would no longer be a viable suspect in the murders due to Richard Allen's conviction. Funny. Not knowing whether Allen could be the third person involved in the murders, Reese Davis asked Keegan Kline whether Mr. Allen was the third person involved in the murders. Kline replied that Richard Allen was not the third person and had nothing to do with the murders. Kline further revealed to Davis that he and Logan knew each other through the sharing of child pornography that they shared on burner phones, that they would see each other every 3 to 6 months so that Kline could assist Logan with using the burner phones because Logan was inept with working with electronic devices. Reese Davis further explained that once Kline began revealing his role in the murders, sometime in the summer and fall of 2024, before Mr. Allen's October trial, he, Reese Davis, began sending letters to Nick McLeland, providing many of the details of his conversations with Kline. Now, this is a serious problem. Before the trial, this guy, Reese, is sending letters. And so here's the thing, and this is what this motion is all about. The defense never received any of this during the trial, or before the trial. It was not in the discovery, so they never got any of this information. And they're asking McLeland, "Did you get these letters? Did this guy actually send it, or is he just bullshitting us?" So this is a serious problem now for the state, because, and I'll tell you, the state has not responded to this. The judge has not denied this motion. So the state is going to have to respond. You would think, right? They would need to respond to this motion and say whether they actually received these letters or not. There's some debate. Apparently, from my understanding, uh, uh, because Andrew Baldwin was on Defense Diaries a couple nights ago and revealed that they know for a fact that that McClelland received the letters. It may not have been him personally, but his office received those letters that they got there. So what happened to that stuff? Why wasn't it in the discovery? Why did it not come to light until now, after the trial is concluded? So there's a lot of issues here. And if that is the case, this is newly discovered evidence. And they're going to have to answer for that. So I'm interested to see what comes out. Now, again, this doesn't mean that it's true, right? Reese Davis could be lying. But if it is true, there's a serious problem. So Reese Davis further explained, oh, nope. Reese Davis indicated that he believes he sent as many as 8 letters to McClelland, to the office, and presumed that McClelland was sharing the contents of those letters with Richard Allen's defense team. Anthony Baldwin met with Reese Davis on March 27th, 2024, and learned very limited information from Reese, who encouraged Baldwin to watch a videotape interview that law enforcement had conducted with Reese years earlier, right? At their February 12th meeting, Reese Davis further admitted that when Attorney Baldwin met with Reese in March, that he did not provide all of the details he knew at the time, for 2 reasons. He had not heard all the details yet that Keegan Kline had provided him, including that Kline was ever involved in the crime and that Keegan knew Ron Logan. And number 2, at the time that he met with Baldwin in 2024, he could not be sure whether Richard Allen was the third person involved in the murders. He had no idea. It says Mr. Davis stated that he was guarded during their March 27, 24 meeting with Baldwin because he did not necessarily want to assist Richard Allen's defense counsel if Allen was one of the 3 men that Ron Logan stated was involved in the murders. So he was worried at that time that Allen was actually the third guy. And so he didn't want Allen to get off if he knew that he was, in fact, the third, if he would have found out that he was, in fact, the third guy. He also, there in this videotape, Reese Davis says that he believes that Baldwin would have understood everything from the videotape. Now, this videotape was never shown to the defense. They had never seen this before, never seen any video with Reese Davis in an interview. So he was like, just watch the video. You'll get everything. So now, with all of this information, Baldwin then emails Nick McClelland and says, hey, hand over the videotape. We need to see this. No response. The prosecution has never provided any response to any of the messages from Baldwin saying, hey, we need to see these letters. Did you ever get the letters? Did you see the letters? Do you have the video? And so the whole purpose for this motion is to preserve this evidence, to say, hey, I don't want you guys erasing this shit. We already know that there was all of the stuff from Brad Holder, Elvis Fields, all of it erased. We know that all of the transcript or all of the files and everything from Monica Walla, all destroyed. All of the video that was supposed to be taken or was maybe not taken, no video evidence of any of the meetings with Walla. right? So there's a lot of issues in this trial about destroying evidence, making evidence disappear, making it find itself erased, however you want to put it. There's a lot of times in this trial. So the defense is now scrambling, like, hey, we need this evidence. We need you to preserve it. We need a court order to make sure that this evidence is preserved so that we can have it and review it, because this may be the new evidence that we need to get this overturned or to go to appeal. So, this is groundbreaking in this case, because now what we're looking at, right, is the possibility that, yeah, Richard Allen had nothing to do with this, that Ron Logan and Keegan Kline and somebody else now, a third person. Oh, funny that we've all been talking about that there's no possible way that this could have been done by one guy. Now, here we go. There's three. Now, what does that mean? Because, we looked at all the Odinism stuff, and we talked about Odinism, and we talked about Brad Holder and Elvis Fields, and, the other two people that were involved there. Now, Baldwin brought up something really interesting that, or kind of in passing, that I thought was really good, is that, like, these guys knew those people. They knew that Odinism was a big thing in the Indiana area. Maybe they did those things to try to throw somebody off the scent and try to cast some doubt and push the narrative over to, hey, we know that Brad Holder's son is dating one of the girls. So if we stage this to look like some kind of ritual, then maybe they'll think it's those guys, and then they won't look at us. So I thought that was a good point, that maybe that is the case. Maybe that's what happened there. But this motion is still out there. There is still this motion to preserve evidence and to look into this. So I don't know what's going to happen from this. Hopefully, some things will come up, and the defense will get what they need to really investigate this, so that we can find out if Reese Davis is lying altogether, or if Keegan Kline and Ron Logan and somebody else are complicit in this murder, and that Richard Allen is not. There are many of you out there that feel that Allen is innocent. There are many people out there that feel like Allen is guilty. But man, this casts a lot of doubt. You have all these people confessing. And, even Elvis Fields, when he talked about, he thought that maybe somebody might have taken his saliva and put it there on the scene. I don't know. These guys are in and out of prison. Dealing in like child pornography and all kinds of stuff. We know that Keegan Kline was talking to one of the girls online through a fake profile. Right? So, like, there's a lot of connections here that need to be explored. Now, here's the other thing. As of yesterday, I believe that means that was the final word on this trial, which means that the defense has 30 days from yesterday to file for appeal. So what we're going to see over the next week, maybe 2 weeks, because I'm sure that the defense is already working on this, but the appellate lawyers, like, tagged in, they're going to go in there and they're now going to do what they need to do to get this in the appellate court. So it'll be really, really interesting to see what happens from here on out. This is by no means the end of the Delphi saga. There is so much more to talk about. There is so much more that needs to be investigated, because we all know that, the Richard Allen angle, there's a lot of reasonable doubt there. How he ended up getting 130 years is beyond me. Because to me, when I look at that trial and I look at the evidence, there's a lot of reasonable doubt. Doesn't mean that he's innocent, but there's just reasonable doubt to put a guy in jail for 130 years. So, you wonder about that. And then on top of that, now there's all this new information coming out, these other confessions to Reese Davis, Ron Logan, and now 7 years later, Keegan Kline confessing. So, I don't know. I don't know what's going to happen from here, but I think it's fascinating. And what I want you to do is I want you to make sure that you comment below, you engage, and let me know. What do you guys think? What do you think out there? Is there anything to this? Do you think that Reese Davis is being honest? Do you think he wrote those letters? Do you think it's all complete horseshit and that Reese Davis is just a meth dealer and meth addict and he's lying his ass off? Let me know. I'm interested because I don't know. I don't know if there's some validity there, but I do know that there's a lot of connections and there's a lot of craziness in this case. And I'll be interested to see where it goes and what happens from here. But those are the motions, the post-trial motions. We'll see what happens. I believe, and I told you before that I thought that it was going to go to an appeal anyway. Whether that ends up being ineffective assistance of counsel or this ends up being new evidence that will lead into, an appeal. I don't know. But it's going to be fascinating to see what happens. And I'll be here to recap some of the things that go on. There will be a whole bunch of us that are watching this in eager anticipation to see what happens. And hopefully the girls will get the justice that they deserve. Richard Allen will get the justice that he deserves. And in the end, the people that are involved in this and that have been involved in this will get the justice that they deserve. So keep on keeping on, and I will see you guys soon. Look at that. You all got 2 episodes this week. I didn't even intend to do that, but you got an extra episode, another Delphi one. We will be back next week to recap the episode with Bruce Lemaster and also talk a bunch about this. I'm sure Mary and Sherry will be ready to talk about Delphi and all the stuff that has been involved in that. And I need to hit up Cryptix because I should bring him on here too, so that we can talk. So anyway, I've been thinking about that the last couple days. Cryptix, we've not talked about that up until now, but I'd love to have you on my podcast too. I've been on yours twice, but I'll bring you on here and we can talk about all kinds of things too. So anyway, guys, I will see you all soon. Like, comment, subscribe, do all that stuff. And by the way, go and put this shit on repeat and leave it playing in your house all day long so that we get our viewer hours up because we are real close to being monetized. So we've got the subscribers. You guys have come through and really started watching and at least subscribing to the channel, but now watch some of the content so that because we got to be over 1,000 subscribers and have at least 4,000 watch hours to become fully monetized. And right now, I think we're at like 2,500 watch hours. So we're a little over halfway there for full monetization. But if we get to 3,000 watch hours, I can apply for the pre monetization. So get on there, put that shit on repeat so that we get those watch hours up so that we can get monetized and I can keep bringing you all this content and even better content because then, it'll start paying for itself and I don't have to buy all these programs and everything else, out of all the other money that I have, don't have, whatever. Anyway, we will see you guys soon. Thank you for joining us. Comment, like, subscribe, watch. Talk to y'all soon.